Thanks for your patience. I apologize for the slight delay here. I had to go make a sign-in sheet. Didn't realize I wasn't going to have one. I'm going to get us fired up in just a second here, but I just wanted to reiterate, is there anyone else who is going to testify today? Okay. Just checking. Good? Sorry? Yeah, I was just checking with you. You're good. All right, Brittany, we're going to go ahead and go. Okay, let's go on the record. Good afternoon, everyone. Thanks for being here today. The Public Utilities Commission of Ohio has scheduled for hearing at this time and place case number 22-1024 AU COI, which is captioned in the matter of the Commission's investigation into the implementation of the Federal Infrastructure Investment and Jobs Act's Demand Response PURPA standard. My name is Jesse Davis. I am the attorney examiner assigned by the Commission to hear this case. The subject of today's hearing, as you know, is the implementation of one of the programs under the Federal Infrastructure Investment and Jobs Act of 2021, which I'll refer to as IIJA going forward. Amendment to the Public Utility Regulatory Policy Act, which I'll refer to as PURPA going forward. Specifically, the purpose of this hearing is to solicit public input on implementation of the Demand Response Practices Standard amended by the IIJA. This hearing is being held pursuant to 21 U.S.C. 2621B1. I will note that this is not a question and answer session. It's an opportunity to offer any information you feel is important to be considered by the Commission in its deliberations as to the implementation of the Demand Response PURPA standard. Further, following today's public hearing, the Commission may issue additional orders and filings, but not necessarily in this case docket. The detailed continued implementation of the various IIJA programs, including the PURPA electric vehicle charging standard case, will go forward. That case number is 22-1025 AU COI. And if anyone is interested, the overall holistic case number for the IIJA at the Commission is 22-755 AU COI. Today's hearing is being transcribed by a court reporter. If you do plan to comment, please speak clearly so that the court reporter can accurately reflect your comments on the record. The Commission appreciates your participation in today's hearing, and we want everyone who intends to comment to have the opportunity to do so. So it looks like we just have a couple folks signed up today, so without any further delay, we're going to go ahead and open up the floor to commenters. And first we have Ambrosia Wilson and Amy, I apologize, Botchner O'Brien from the Office of the Ohio Consumers Council. So if you want to come up to the witness stand. There should be a button on the microphone there.
They're always on.
Oh, are they always on? Okay. Thanks, Brittany. I'll just ask you to state your name and your business address.
Ambrosia Wilson, 65 East State Street, Suite 700, Columbus, Ohio, 43215.
Thank you very much. You can go ahead with your testimony.
Good morning. My name is Ambrosia Wilson. My comments today are on behalf of the Ohio Consumers Council for Ohio residential utility consumers. OCC appreciates that the IIJA can provide benefits to utility consumers. The IIJA includes a requirement that each state regulatory authority consider the demand response standard in the federal PURPA. The PUCO is such a state regulatory authority, and under the IIJA, the PUCO must decide whether it is appropriate to implement the standard. The IIJA provides $1.2 trillion for investment in utility infrastructure across the country, and the law provides nationally for $73 billion of funding for electricity systems and utilities grid improvements. There is also $12.5 billion for electric vehicle chargers and buses. Electricity system and utilities grid improvements are tied as the third largest funding target in the IIJA. In this docket, the PUCO is considering the IIJA funding for demand response programs. Importantly, participation in demand response programs must remain voluntary for consumers, and consumers who choose not to participate should not be charged. Examples of demand response programs are time-based rates, such as time of use pricing, critical peak pricing, variable peak pricing, and real-time pricing. It also includes direct load control programs, which provide the ability for power companies to cycle air conditioners and water heaters and other large appliances on and off during periods of peak demand in exchange for a financial incentive and lower electric bills to consumers if they voluntarily choose to participate in these programs. Demand response programs are a subset of DSM, but OCC's comments are not intended to be attributable sorry, to DSM programs like low-income weatherization programs, for example. The demand response standard requires the PUCO to consider, first, whether the electric utility should promote the use of demand response by consumers. 2, whether the PUCO should authorize utility rate mechanisms that would allow the utility to charge consumers for those, for those promotional efforts. OCC recommends that a utility play a limited role in promoting demand response programs and that the role should be one and that the utility should not charge consumers for promoting demand response. The utility's role should be one to enable the development of demand response programs through the competitive market. The utility should not be an impediment to the development of demand response programs. Consumers have already been charged hundreds of millions of dollars by their utility for smart grid and should not pay additional subsidies to the utility to supplement demand response programs that are provided through the competitive market. To further clarify, utility-sponsored demand response services should not be authorized by the PUCO as a non-competitive retail electric service under Revised Code 4928.01B. Ohioans should benefit from the funding available under the new law. Those benefits should be delivered where feasible through competitive markets and not through monopolies charging consumers more. At this time of soaring energy prices and inflation, the new law should give Ohio consumers more benefits with less costs. Thank you.
Thank you very much. Thanks for your testimony. And any last minute holdouts? Anyone who's changed their tune? Felt compelled? Okay, well, going once, twice, and we'll call that no. Thank you all for being here today. I think with no one else left to testify, that'll about wrap us up. I would note that a transcript for this will be in the docket under case number 221024 AU COI, searchable on the Commission's docketing information system, and that'll probably arrive within a week or two, maybe a little more. And then, of course, there's still opportunity to submit public comments. The formal comment period has closed. And again, thanks to you all for being here. We are adjourned.